Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're bringing you the news behind the news in this video blog special. Similar to blogs on the internet, Full Disclosure produces short videos of topical issues on our website where we pose questions and invite our web visitors to add their comments to the discussion. We've assembled 3 of these controversial programs for you to enjoy here today in this video blog special. Isn't the state bar supposed to protect the citizens from scurrilous lawyers? Not according to Dr. Richard Fine.
The state bar, by both history and statute, is an arm of the judges.
That's right. According to him, the state bar is the muscle for the judges. They are the court enforcers.
The California Supreme Court has said in cases that the state bar is an arm of the California Supreme Court.
Mathematics professor Dan Gottlieb was a member of the Marina Strand Colony II Homeowners Association who hired Dr. Fine to represent them in a lawsuit against Jerry Epstein, a high-powered Los Angeles developer. Epstein was about to build a towering new apartment complex right over Professor Gottlieb's home on county-owned property. But then suddenly Dr. Fine was abruptly removed at the most inopportune time.
2 weeks after he signed up with us, the state bar initiated a probe of him, initiated an investigation. And at that time, the head of the president of the state bar was Sheldon Sloan, who was actually hired by Epstein, who was the developer that we were fighting.
When facing the invincible Dr. Fine, Jerry Epstein hired Sheldon Sloan, the president of the California State Bar, and then Dr. Fine was confronted with disbarment proceedings. Only a fool would consider this coincidental, and Dr. Fine is bent on proving the collusion.
Just last week, the state bar admitted that the entire state bar complaint and proceedings was basically a fraud, because I filed a lawsuit against the state bar board of governors, the judges of the state bar as they're called, and the chief trial counsel of the state bar, and meaning he and all of his staff. These are the people who are so-called were prosecuting, and the judges of the California Supreme Court.
So what was the justification for facing disbarment at this critical time? Professor Gottlieb has his opinion.
If they were trying to retaliate against Fine for suing the Epsteins, then that's secret. They couldn't say that. But that's what I think.
Perhaps it wasn't merely retaliation for suing the Epsteins. Perhaps the disbarment proceeding was orchestrated by the state judges, since Dr. Fine has accused them of taking illegal payments from LA County. Those payments had been ruled unconstitutional in the Sturgeon versus County of LA case.
State bar admits to that. They have one line in their brief responding to my brief in an order to show cause in the Ninth Circuit that says exactly that. It says that I was disbarred for filing, they call it frivolous cases, against the judges. And of course we know that there were no frivolous cases, so that's what I was disbarred for.
Professor Gottlieb thinks the action was more Machiavellian. Who was it that told you that the state bar can be used for that purpose?
The first person was a lawyer from Arizona, and then I have a friend who's a lawyer, and I was just talking to him yesterday, or the day before yesterday, and he said he seemed to be, oh yeah, and he was shocked that it went to disbarment, but apparently it must be a dirty secret that knows that these big powerful people who have ins on the state bar can use the state bar to launch investigations into other people.
Although disbarment was a rare conclusion of the other harassing investigations, Dr. Fine knew that once the proceedings began, he was doomed.
The state bar proceeding was extrinsic fraud and corruption, and therefore it was void. And the reason for that is that 5 of the 7 Supreme Court justices received illegal payments from the counties, and then you had 2 presidents of the state bar who were in litigation against me as attorneys for Mr. Epstein or the county of Los Angeles. And then, so you had all of this prejudice that was going. There was no way that I was going to get a fair trial in either the state bar or the California Supreme Court.
If this is so commonplace, then why aren't the more ethical people in the legal profession raising this as an issue?
The judges are saying, you go against us for our doing these criminal actions, we're going to throw you in jail and throw away the key, and we're going to disbar you. That's what this is all about. Naturally, any attorney looking at that is going to say, the hell with the law. Forget about my oath of office to uphold the Constitution and everything else. I'm not going to risk this. I'm going to keep my mouth shut. They are not going to stand up for something that is wrong because they figure, let it happen to the other guy, and I'm just going to keep quiet and just keep going along, and these judges are going to do what they're doing. But
He vehemently disagrees with that ostrich approach. No one ever won a fight by appeasement.
These corrupt judges are minuscule in compared to the population of California. And yet the silence has allowed 1,900 corrupt people to remove the democracy and the constitutional rights of 38 million people. That has been the effect of no one standing up for it. Well, I stood up for it at tremendous cost. And now it is getting exposed. And now we will get rid of these 1,900 people. They are minuscule when you think of the 38 million people that live in California. And they will go.
We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1. Do you think the California State Bar Association is being misused by the judges to deter attorneys from exposing their judicial abuse of power? Yes or no? Number 2. Do you think that the silence from the legal community and the law schools regarding judicial abuse indicates that they approve of silencing dissent? Yes or no? And number 3. Do you believe that judicial canons of ethics are set forth by the Constitution are meaningless? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you. Dr. Fine is turning up the heat. He's declaring that the judges of Los Angeles Superior Court are part of organized crime and should be prosecuted under the RICO statute.
No question about it. It's a federal violation. And essentially, if the United States U.S. Attorney or if Attorney General Holder has the guts to prosecute these people will be in jail in what we call a New York minute.
This is an extraordinary accusation. We asked Dr. Fine to explain this serious charge.
You have a group of members of the judiciary that have effectively engaged in what we call a RICO scheme, which is a Racketeer Influenced Corrupt Practices Act scheme. And the basis of the scheme is that you have the illegal payments, you have them taking place time and time again, you have the judges obstructing justice that is a RICO scheme.
And so, according to Dr. Fine, this corruption of racketeering isn't just isolated only to the Los Angeles Superior Court.
The entire judiciary system in California is susceptible to this scheme, and the 38 million people of California are victims of this scheme.
Dr. Fine has the evidence to back up his claim of judicial corruption.
90% of the judges in California received illegal payments. And that goes all the way up to 5 out of the 7 California Supreme Court justices received those illegal payments. So the system is rife with obstruction.
If the judge is receiving payments from the county and one of the parties appearing before him is represented by the county, aren't the judges supposed to disclose this fact to everybody in the courtroom?
Oh, there's no question. The responsibility existed under the Code of Judicial Ethics, Rule 3E, 3E1 and 2. The responsibility existed to not even accept the payments under the Code of Judicial Ethics, 4D1. The responsibility existed for the judges to tell other judges about these illegal payments, and that is under the federal statute, the misprision of felony, and that is 18 U.S.C. Section 4, which makes it a federal crime. It's a federal crime for someone who knows of a crime being committed to not tell a judge about such crime. And that's a federal crime. And state court judges are bound to follow federal law, and that's under Article 6, Clause 2 of the United States Constitution.
Perhaps we're being optimistic to hope that some judges somewhere in the entire state recognizes this obvious conflict of interest and is refusing these illegal and unconstitutional payments. Isn't there at least one judge with integrity in the state?
To my knowledge, I don't know of any judge that has turned down any payments.
So if they're all taking the payments, shouldn't they at least inform the parties they're judging? We asked Dr. Fine who's responsible for making sure everybody knows there are illegal payments being paid to the judges.
Well, their responsibility is going to fall on two people. One is going to be the judge. The second place is going to be on the county council, if the county's in there, because the county council would then be misleading and deceiving the court and actually committing obstruction of justice. So if the county council does not come in and disclose that the county is paying or has paid illegal payments to the judges, the county has committed obstruction of justice. Now, when the county knows that they made the illegal payments and the judge knows that they've made illegal payments, the two of them together have committed obstruction of justice, and they have precluded the other person in the lawsuit from obtaining a fair trial. Now, that results in two things. One, that results in a denial of due process. In addition to that, such action is going to be an obstruction of justice, because what has happened is that LA County has bought the judiciary. And by doing that, they have obstructed justice by also denying people a fair trial. Now, a third thing takes place, and this is that they've committed an extrinsic fraud upon the court, because what they've done by having bought the court, they've stopped the other side from obtaining a fair trial. And when you do what is known as an outside action of stopping the other side from obtaining a fair trial, you've committed an extrinsic fraud, because that's something that the other side really can't find out about, and it has nothing whatsoever to do with what the case is about. If it had something to do with what would be the proof of the case, it would be considered an intrinsic fraud, and it would be something that the other side could prove within the confines of the case. But this is something totally outside of the case, what we call collateral to the case. So it becomes an extrinsic fraud, and the cases hold that when one party does something or something happens that is outside of the case and it prevents, through any means whatsoever, someone getting a fair trial, that's extrinsic fraud, and that actually deprives the court of jurisdiction. And when there's no jurisdiction, anything that the court does is void. So that gives you sort of a picture of what is happening here.
And the picture is looking mighty bleak. We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1, do you think that the cover-up of the illegal payments to judges should be considered racketeering and should be prosecuted under the RICO Act? Yes or no? Number 2, do you think that by the judges not disclosing the illegal payments to the parties in the courtroom should be considered obstruction of justice? Yes or no? And number 3, do you think that judicial acts of extrinsic fraud are more serious than obstruction of justice? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you. Kelly Thomas was beaten to death by the Fullerton Police Department. 2 police officers have been charged with felonies in his murder. How can a police department that has been charged specifically to protect its citizens go so far from its delegated task? In our pursuit to get the news behind the news, Full Disclosure interviewed Fullerton City Councilman Bruce Whitaker to find out how the leadership of the city lost control of their police department.
My wife and I went to the memorial for Kelly Thomas, which was held in Yorba Linda. And, you know, in public life you attend a lot of funerals. I've never seen a cross-section of people like attended this one at the church in Yorba Linda.
People everywhere were alarmed at how a simple arrest of a non-compliant suspect could require such extreme brutality. Councilman Whitaker isn't one to sit around and wait for the lawyers to sort things out.
I was thinking, well, you know, now I'm recently elected city council member in Fullerton. I am in a position to make a difference. And so I've pledged myself to assure that if I can, I will make a difference in the future.
His first mission is to get all the facts before the public, but he has met considerable resistance.
A couple days after, well, in fact, I think it might have been the same night or the next night, I drafted my letter demanding and pledging support that all video and audio recordings of what occurred be made public. And I urged any members of the public to come forward with information on that. And I believe the public has a right to see what really transpired there, and I do want to see that ultimately happen.
Even as a duly elected public official, he has been kept in the dark.
At this point, even as a council member, we've been denied that ability. One other council member and myself sat down with the city manager and demanded to see the surveillance video, and it was denied.
How can Joe Phelps, the city manager, deny the elected officials who are his boss access to the video and audio recordings of the event? It comes from the risk management attorneys, whose goal is not to serve the public, but to minimize the liability of the city, as Councilman Whitaker explains.
Our legal advice, if I were to just boil down the legal advice we've gotten both behind scenes and also in open public session, would be that we should put a muzzle on and sit on our hands for many months until investigations are completed. But that's untenable. That's something that just it can't happen. As city council members, we're the only elected representation in city government. We're the only people who, it's the meeting point between the residents and their city government. And so if we chose to do that, there would be no voice or no representation whatsoever.
But what role does the chief of police play in this tragedy?
You know, I'm a fairly new council member. I got along fine with Chief Sellers. He's a nice guy. I felt as a council member that we had an expectation of a chief to get in front of something like this, to put a personal face on it to get in front of some cameras, he and or the mayor, to do the right thing, to express the appropriate levels of grief and concern about the victim and his family, and to reassure the public that at the end of this that we're going to have a just decision rendered. And at first, as council member, I waited just a little bit for that to happen, and then I realized that wasn't going to happen for whatever reason.
And Bruce is prohibited from direct contact with the police department. He's required to go through Joe Fells, the city manager.
The reporting function from the council is through the city manager to the chief of police. I had made several requests of our city manager for information that would help me to make decisions, not just on Kelly Thomas, but we had a death in custody of a prisoner back in April of this year. And there were some unusual circumstances around that as well. So I had made some inquiries into that through the city manager to the chief, and none of those were granted. I mean, information that I wanted and or wanted to be explained, you know, certain procedures and capabilities that we had, and that wasn't happening.
So the city manager is the gatekeeper of information for the Fullerton City Council. And apparently that information isn't as accurate as it should be.
Initial reports that we got, other facts that have come along throughout the chain, much more fictional or fictionalized than now what I believe to be the facts. So I think a city council member, as one of the board members of the incorporation of the city of Fullerton, that there needs to be a consequence for department heads or other employees forwarding inaccurate or false reports up through to the decision makers. I mean, it's one thing to say there are sensitive details we can't allow, but to actually have reports that are not true at all, are provably false, and to have a series of these that create a narrative that would take us in completely the wrong direction. I have a vested interest in sending a message that that's not okay, and that there are consequences for that.
We ask him to give us an example of how the official information is being distorted by city bureaucrats.
I've found in this Kelly Thomas incident that the Friends for Fullerton's Future blog and eyewitness accounts and people in the street, emails that I would receive, inquiries I'd make or get answers, those have been so much more accurate at this point, at least seem to be in line with what the district attorney has come up with, than anything I've received as internal communication as a city council member. And so, you know, how do I operate as a council member in the future? I may have to just completely disregard our official line coming through the city, you know.
This is a serious charge. We asked him what is he going to do about it. He was very direct about how he plans to confront them.
It's not okay to lie. It's not okay to lie internally. It's not okay to lie to your bosses and to perpetuate a lie. It doesn't matter to me how self-serving that may be, and that's just human nature. No, we're talking about sworn public safety officers who we have a right reasonably to expect that their reports be accurate and that their representations be accurate.
He is all about bringing a refreshing new philosophy in government, transparency.
I'm going to, in my span, I don't know how long that span will be as an elected official, but in whatever span that I'm serving as elected official, my goal is going to be open up government, open up a lot of the processes and steps, conduct business openly before the public we serve. And that's, you know, it's as fundamental as this. Government is the servant, not the master. And left to its own devices, government will create itself that catbird seat position of authority and master over the public it serves. And so that's the tug of war we've been engaged in.
And so, even as an elected official, he sees that he must fight the bureaucracies, just like the citizens, just from a different perspective, being that he is supposedly in charge of the bureaucracies.
There's been that fundamental question at the base. Who is the servant and who is the master? And I believe that the founders of our country and our Constitution very firmly, and in fact, I'm sworn to uphold the California Constitution and the U.S. Constitution. And those two documents make it very clear to me that the public is the master of these instruments of government that have been created to serve that public.
And once we force government back into its limited box, as he suggests, we as citizens need to keep an eye on it, because it will always be looking for every opportunity to expand its reach and control.
Then we as a public need to establish boundaries and hold government to those boundaries. And part of that, we are a nation of laws. I don't think it's asking too much to expect the government who drafts the laws to abide by the same laws.
Imagine that, government actually following its own laws. How revolutionary. Councilman Bruce Whittaker is dedicated to getting the Fullerton City government back into its limited box and back under the control of its citizens.
When the district attorney came out with his report the other day, I wasn't surprised by hardly anything. That's what I had pieced together on the outside. But it varies so much from what the official reports have been that I'm just trying to see how I deal with that now internally, management-wise. Now, I'm one of 5 on the council, but I can be a pretty persistent one of those 5.
We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. The city manager and the risk management team for the city of Fullerton has been stonewalling the city officials elected to oversee them. So, question number 1 is, do you think this is government out of control? Yes or no? Question number 2, do you think the 2 Fullerton police officers that have been charged with the death of Kelly Thomas and those who stood by and watched did so knowing that the city manager and the risk management people would protect them? Yes or no? Councilman Whittaker is pressing for the audio and video records of what happened and to punish those who lied to the city council. This could put his political career at risk by possibly alienating the bureaucracy and the public employee unions. Question number 3 is, do you think his efforts to establish government accountability and transparency in Fullerton will doom his political future? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you. This concludes our video blog special. We're interested in what you, the viewers, think. If you would like to answer any of these survey questions posed by these video blogs, or if you'd like to make comments, please call our Full Disclosure Town Hall number at 1-800-867-7777. That's 1-800-867-7777. And if you leave your name and number, we'll get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. I'm Leslie Dutton. Please join us next time for another edition of Full Disclosure. Thank you.
To respond to this question or comment on this program, please call 800-867-7777 or visit fulldisclosure.net. Transcripts or DVD copies of this program are also available on our website. Full Disclosure, the news behind the news. Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're bringing you the news behind the news in this video blog special. Similar to blogs on the internet, Full Disclosure produces short videos of topical issues on our website where we pose questions and invite our web visitors to add their comments to the discussion. We've assembled 3 of these controversial programs for you to enjoy here today in this video blog special. Does David Hernandez have any chance of getting a fair trial here in Los Angeles? He's spearheading the drive against 2007's Proposition R, which loosened the rules for lobbyists and extended term limits for the LA City Council members. Now he's discovered that Judge Yaffe, who decided his trial, was getting over $800,000 in bribes from the county, the same people who certify the integrity of the election. Dr. Richard I. Fine has been fighting these judicial bribes for more than a decade. We asked him what he thought of Mr. Hernandez's chances in the LA Superior Court.
His chances of getting a fair hearing are zero. And that's going to be based upon the following things. Number one, it's well established that Judge Yaffe received illegal payments. I think the exact number that we had was $827,000, and that was based upon from 1989 to through 2010. I believe that Judge Yaffe became a judge somewhere around 1987 or so. So if you add those other couple of years that we didn't have, you're probably looking around $860,000. So basically, in Hernandez's case, Yaffe was disqualified before everything even began. Okay, so now we're looking at a present LA Superior Court judge ruling on Judge Yaffe's actions. You take any judge that is sitting and you find out if this judge has received LA County payments. If the judge received LA County payments, that judge is going to be out. LA County basically says, I believe they're claiming that they're giving about $30 million a year to the judges, and I believe that they're claiming that they're paying off every judge. So if they're paying off every judge, what would happen that there's no judge in LA County that could even hear this case. As long as the judge is getting or has gotten a payment, the chances of his being fair are zero. You have to go to a county where the judge has not received payments and where the county historically has not given the payments. Then you stand a possible chance of the judge being fair.
So, is Dr. Fine advocating that Mr. Hernandez should get the trial moved to a different county?
Absolutely. I think that they don't really have a choice. They're going to have to change venue with him. So all he has to do is make the motion, put up the money to transfer the file, and the change of venue will take place.
In response to Mr. Hernandez filing against Yaffe's decision, the LA City Attorney has just slapped Mr. Hernandez with a $1,200 sanction for filing a frivolous lawsuit. We asked Dr. Fine to explain how could they do that.
First of all, it's a retaliation, it's a scare tactic, and it's illegal. Number one, you can't ask for sanctions without giving what they call a 21-day notice. So they're breaking the law right off the bat. So what is happening is that they're trying to scare the hell out of him. And that in and of itself is illegal. And the city attorney knows this. So what he's doing is that he is going forward, he is deceiving the court, he is intimidating Hernandez, which is against the Code of Professional Conduct. So he's doing all of these things, knowingly doing this.
Well, is Mr. Hernandez off base with this lawsuit? According to the judges, what appears to be illegal and unconstitutional payments have been made perfectly legitimate by the state legislature when they passed Senate Bill SBX 211.
SBX 211, and particularly Section 5 of SBX 211, which gives the judges and the county employees and the counties retroactive immunity from criminal prosecution, from civil liability, and from disciplinary action, is unconstitutional.
So according to Dr. Fine, Senate Bill SBX 211 itself is unconstitutional. In this country, the rule of law exists to assure that we are all working with a level legal playing field. If the judges can pass an unconstitutional law to protect unconstitutional payments to themselves, it appears that the judges think they are above the law and beyond the control of the citizens.
They are out of control with this immunity because of the fact that the retroactive immunity that they have been granted has placed them totally out of control and totally outside of the law. They have become literally a kingdom unto themselves, no longer subject to the California Constitution and basically no longer subject to the United States Constitution. Bottom line, SBX 211 is unconstitutional any way you cut it.
The judicial system is the third branch of our government. Without the checks and balances provided by that third branch, everything America stands for is in jeopardy. Dr. Fine has a remedy.
We have no choice other than going in and getting rid of these people. If they're elected officials, get them out. Either through recalls, or if they run for office again, get them out.
That requires an informed electorate. Voters need to know which judges are taking these illegal payments. If people will take the time to become informed, we can regain our judicial system.
Now the question is a dirty judicial system and getting it cleaned up. And that's where we're at.
We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1, do you think the state legislature has the authority to change the Constitution and make the payment to the judges legal? Yes or no? Number 2, do you think any judge will decide against another judge if they have both received the same illegal payments? Yes or no? Number 3, do you think the LA City Attorney is protecting his pals in the Superior Court by imposing sanctions on citizen watchdog David Hernandez? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you. In an unprecedented budget cut, the California Bureau of Narcotics Enforcement and the Bureau of Investigation and Intelligence, which are state-mandated programs, are being utterly dismantled. Carrie Cavallari is a member of the Board of Association of Special Agents in the California Department of Justice.
We used to have over 600 agents, and over the last several years, that's dwindled down by not being allowed to hire additional people. And then suddenly we have a major cut that's going to basically cut us in half from under 400 to approximately 200 or less.
These two agencies, known as BNE and BII, provide an extremely important service to local law enforcement throughout California.
In order to do surveillances, we usually had to borrow from our other sections and other teams, and this would devastate a lot of our most effective operations, whether they be undercover operations, infiltrating criminal organizations, sexual predators. We had agents that were assigned to track sexual predators as part of a task force. Some of them have already been pulled out. Also, in the case of gang enforcement, we have agents both in B&E and the Bureau of Investigation and Intelligence. They're not going to be there. That's very rewarding for the gang members. It's not so rewarding for the citizens.
In Southern California, there have been massive raids involving street sales of OxyContin purchased through Medi-Cal fraud. Due to the investigative work of the BII, the people in these criminal organizations have been arrested and indicted. But as Agent Cavallari explains, if these planned cuts are allowed to proceed, there is a danger with cases that are currently being prosecuted.
That's going to affect cases that have already been done, because the agent who did that case may be laid off, may be out of state, may be unavailable. So then you're probably going to end up with cases being dismissed. That's a good possibility.
His organization has filed a lawsuit to stop it. The question is it too late? Is this a done deal?
The budget is set in stone currently, okay? These will occur unless something changes. It's not a matter of, well, could this occur? This is happening. Agents have been advised as part of the process that, you are in danger of being laid off, and then originally it was supposed to be December 1st, but it's been postponed temporarily that they didn't receive their final notices. As to why, we were not advised why. Now, it may be a procedural matter. But what happens is, once they've given that notice and once they leave, rebuilding that would take years.
We ask him why Governor Brown has specifically mandated these cuts against the Bureau of Narcotics Enforcement and the Bureau of Investigation and Intelligence. Governor Brown was the Attorney General before running for governor. He knows that these agencies have been invaluable to California law enforcement for decades. What possible motivation is there for him to disband such productive and successful organizations?
As part of our lawsuit, we did mention that we believed that the governor's decision was predicated upon the fact that we seemed to be in favor with him prior to the election for governor, and then CSLA endorsed Meg Whitman. Suddenly we go from being a necessity. Matter of fact, in one statement prior, he said, in tough budget times, you don't cut law enforcement. And then after that, he cuts law enforcement. Not only just law enforcement, but the people he had working for him. He didn't cut us while we were working for him, but then he cuts us after he leaves. That would be a question to ask, why and what caused this to happen.
So what is the Association of Special Agents asking for in their lawsuit? We ask him.
We're asking for that the Attorney General be allowed to determine her own budget priorities and what needs to be done, that she be allowed to move money within her overall budget, and if she decides it would be proper, then backfill the money that's been taken from Division of Law Enforcement. Our premise is that as a constitutional officer, just as then Attorney General Jerry Brown said it was necessary that he be allowed to set priorities, we would think that should apply for her also. Last time I checked, there was, we've made good strides as far as crime, but there's no shortage of it. It's not like, oh, okay, we've solved the crime problem, so we don't need agents. There's plenty of work. We don't have a shortage of work.
It's only going to get worse. Residents of California are gravely concerned about the massive release of 36,000 dangerous felons currently being unleashed from our state prisons. We ask him what we as citizens can do to stop this destruction of the Department of Justice. He was visibly moved by our question.
Citizens can do several things, and of course the agents would appreciate every and all piece of assistance. We're not used to having to ask for help, but this is a situation where every little bit helps. I would say calling their legislator, also communicating to the governor what their priorities are. But the most important message would be unallocate the cuts so that the AG can decide what to do with her agency and let the agents do their job. If they were unallocated cuts and we just were able to fill in behind, okay, yeah, you have to take money from a budget, you have to fill holes, we understand that. The part we can't understand is why are they allocated? That's the thing that makes us wonder, what is it that is so special about the agents that you want to remove such a large chunk of what allows them to function and take people who have expertise and reduce their number and in effect take an agency and make it so that it's ineffective? What purpose does that serve?
Doesn't it serve as a punishment for not supporting him?
In some ways, that's probably the least scary answer. That's something that's kind of explainable, but the other thing is, why would you help criminals by making sure they don't have to look over their shoulder?
In his first term as California governor, Jerry Brown was known for being soft on crime. He appointed the infamous Rose Bird as the Chief Justice of California. Her personal opposition to the death penalty was the reason she was the first and only Chief Justice to be removed from that office by a majority of the state's voters. We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1, do you think this is a matter of political punishment because the special agents supported Meg Whitman over Jerry Brown? Yes or no? Number 2, do you think state-mandated programs to investigate organized crime and narcotics trafficking should be protected from budget cuts? Yes or no? And number 3, do you think that more money will be saved by dismantling these agencies than will be wasted in dismissing the prosecution of criminals due to the layoffs of investigators? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you. Full Disclosure is continuing to document the struggle to restore the integrity to our judicial system in California. A few months ago, civic leader David Hernandez filed a suit to have his case against Los Angeles Measure R reversed by voiding Judge Yaffe's decision. He is now taking his case up to the California Court of Appeals. Full Disclosure's legal analyst, John Barron, describes the situation.
In 2007, his case was dismissed by Judge Yaffe, and he wants to reinstate it so that he can bring the challenge again. He feels that the decision of Judge Yaffe was wrong. And the basis for that is that Judge Yaffe was a disqualified judge because he accepted $860,000 from the county. And even during the trial, Judge Yaffe was receiving the money, and he never disclosed it. And the county council was at the trial, and he never disclosed that the judge was receiving the money then. And that seems to be against several things. One, common sense, but two, it's against the Code of Judicial Ethics. And this should disqualify the judge.
We asked Mr. Barron to explain how Mr. Hernandez is mounting his appeal.
He has moved to disqualify Judge Robert O'Brien. So Robert O'Brien then rejected it. He struck the disqualification motion. And when you have a disqualification motion that is struck by the judge, it cannot be reviewed on a normal basis. It can only be reviewed by a writ of mandate to the Court of Appeal. So that's what this is. This is the writ of mandate to the Court of Appeal to try and have Judge O'Brien disqualified from hearing his case.
On what basis does this writ of mandate disqualify Judge O'Brien? We ask him.
The primary reason is that Robert O'Brien, as a judge, he's a retired judge now, but as a judge, when he was a regular judge on the Superior Court, received over $225,000 in illegal county payments. And these payments, therefore, disqualify him. He has received illegal money from a party in the case, the county.
But apparently there are more issues than merely taking illegal payments.
He was disqualified for taking that money. The second issue that he was disqualified for is that he violated judicial ethics. The third issue is that he illegally struck the petition for disqualification, the motion for disqualification. He failed to answer properly, according to the statutes, the disqualification motion. There's a statute in the Code of Civil Procedure in California that says a judge has to either consent to disqualification or he has to answer and deny the charges. And if he fails to answer within 10 days, he is automatically considered to be disqualified. So he did not answer within 10 days, so no matter what he said in that order, he's disqualified. He's also disqualified under the Due Process Clause of the United States Constitution. In a recent case, the U.S. Supreme Court has held that no man can be a judge in his own cause. And also no man can be a judge where he has a direct financial interest.
A direct financial interest? We asked Mr. Barron to explain how the judges had a direct financial interest.
Judge O'Brien and Judge Yaffe were basically in the same boat. They've both taken money from the county. So if you're asking Judge O'Brien to make a judgment on whether Judge Yaffe took the money illegally, you're asking him to decide that he took the money illegally. So he's unlikely to do that. The second part of it, where he has a direct financial interest, the rest of the mandate here attacks SBX 211.
SBX 211 is another scurrilous tactic foisted by the judges to perpetuate their scam.
SBX 211 is a bill that was passed by the legislature in California to address the Sturgeon decision in 2008, which said that the county, Los Angeles County, was illegally paying the judges extra money.
So how did SBX 211 reverse the Sturgeon decision, we ask him?
SBX 211, passed by the legislature and signed by the governor, purports to give retroactive immunity to the judges for civil liability, criminal prosecution, and disciplinary actions against the judges. This is unconstitutional. And the reason that this is brought up here is because the Due Process Clause says that if he has a financial interest in it, Judge O'Brien, he should be disqualified. If SBX 211 is declared unconstitutional, then he doesn't have any retroactive immunity, and he could be liable. He could be liable for civil and criminal and disciplinary actions. And that's what the judges all fear.
That fear is well placed. So David Hernandez's case hinges on how the appeals court rules on SBX 211.
But in order to argue that Judge O'Brien is disqualified because he has a financial interest, he has to argue that SBX 211 is unconstitutional and illegal, because the other side is arguing that SBX 11 gives them immunity, and they're just not disqualified for having taken the money.
So what is the current status of Mr. Hernandez's appeal, we ask him?
The petition for a writ of mandate has been filed. The other side, the county and the city of LA, have a certain amount of time to file a reply brief to this. Then Mr. Hernandez has a certain amount of time to file an answer to that reply brief. And then the Court of Appeal will schedule an oral argument, probably, and sometimes they do not even schedule an oral argument. They just take it under submission and decide it on the briefs.
Is there any assurance that they will give a ruling on those issues like SBX 211 and his prayer for relief?
Actually, no.
So what recourse does Mr. Hernandez have?
If they turn it down, this writ of a mandate, Judge O'Brien is the judge on the case.
And then he can do anything he wants with impunity. But there's still another avenue available, according to Mr. Barron.
There's also, though, another thing that has been submitted to the court in the Superior Court is for a change of venue, saying that Judge O'Brien, Judge Yaffe, and all the judges who've taken money from the county are disqualified, and that, in fact, the case should be moved to another Superior Court somewhere else in the state where the judges were not receiving illegal payments from the county.
So one way or the other, Mr. Hernandez will get his day in court?
That's very hard to say because there are so many ways in the court that you can be tripped up, that you can lose a point of law or something, and then it will severely damage your chances of getting a fair hearing. Particularly in this case, the issue of venue is very important. It may be impossible, in fact I believe it would be impossible, to receive a fair hearing in Los Angeles County, because all the judges, and in fact a number of the appellate court judges who used to be Superior Court judges years ago, all of them have taken money from the county illegally. And if they have a bias in it, they don't want to decide against themselves.
Why isn't there a major outcry about this issue? Where is the mainstream media? Why isn't the whole country up in arms about this corruption of our judicial system?
It all involves a very sensitive issue. Possible criminal prosecution of judges, possible civil liability to pay back the money, possible prosecution of the county supervisors. The newspapers don't want to spread this around. The Supreme Court doesn't want to see this spread around. None of the powers that be want to see this brought to light.
Where are all the honest lawyers hiding?
Most lawyers will not touch this case or cases like it because they fear being branded as trying to do something nasty to the judges, trying to have the judges disqualified from this and that, trying to have the judges criminally prosecuted, trying to have the judges have to be paying back the money that they took illegally. That's something that no lawyer or any judge wants to see happen.
And so David Hernandez carries on his fight alone on behalf of us, representing himself without an attorney in the courtroom where the judges reign supreme. We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1. Why isn't the mainstream media aligned with David Hernandez? Do you think this is an important issue? Yes or no? Number 2. There is a process where the judges can and should be disqualified due to bias, and it is often ignored by the judges. Do you think citizens should expend the extra time and money and effort to take this to a higher court to make the system work? Yes or no? And number 3, the media has failed to inform the public that all of California judges have received retroactive criminal immunity from prosecution for having taken hundreds of thousands of dollars from county governments all across the state. Do you think we should expose the media cover-up of this travesty? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you. This concludes our video blog special. We're interested in what you, the viewers, think. If you would like to answer any of these survey questions posed by these video blogs, or if you'd like to make comments, please call our Full Disclosure Town Hall number at 1-800-867-7777. That's 1-800-867-7777. And if you leave your name and number, we'll get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. I'm Leslie Dutton. Please join us next time for another edition of Full Disclosure. Thank you.
To respond to this question or comment on this program, please call 800-867-7777 or visit fulldisclosure.net. Transcripts or DVD copies of this program are also available on our website. Full Disclosure, the news behind the news. Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're bringing you the news behind the news in this video blog special. Similar to blogs on the internet, Full Disclosure produces short videos of topical issues on our website where we pose questions and invite our web visitors to add their comments to the discussion. We've assembled 3 of these controversial programs for you to enjoy here today in this video blog special. The electoral process is the very foundation of our republic, where we vote for those individuals who best represent our point of view. But what happens if the voting process is corrupt? Citizens in Orange County were concerned about the results of a local election and wanted to view the process to affirm their confidence in the system. Full Disclosure was invited to come along and record the investigation. Suddenly, they were stopped by the Orange County Registrar of Voters, Neil Kelly. Well, in my request, I asked to review the precinct voter rosters.
Okay.
Okay? That's what we asked to do.
And what would you like to review on those?
All right.
The
We
cover
want
sheets
to
like we talked about, right?
review the back cover sheet and the front cover sheet.
Okay.
And the signatures, but you said that we couldn't, you were going to deny us access to the signatures to verify the counts. Now, have you changed your mind on that?
No, ma'am, that's in statute. There's no changing my mind on that. No, that's in statute.
Okay.
It's not me making that decision. It's the law making that decision.
All right. And who is allowed access to verify the accuracy of what you're reporting?
I'm not sure what you're talking about.
Well,
the signatures themselves?
Yes, the signature count.
If there is an election challenge in court, or if there is a recount, those are the times that we open those up per statute. Otherwise, they're protected. And voters, I would think, would appreciate the fact that those are protected.
Okay, we're not looking to identify the individuals. We're looking to identify the numbers of signatures on each of the pages.
And what you'll be able to do is look on the front of the roster cover to verify that.
So we will be taking the word of the precinct board then.
Yeah, you're taking the word of 80 volunteers who do this. That's correct.
Okay, very good. So we want to see the voter rosters now, and they'll start getting the data off the front and back sheets.
And they're all clear that they're not to open the rosters. Is that correct?
Yes, I'll tell them.
Okay.
We have been instructed not to open the rosters. We are not going to be able to verify the number of signatures on the inside. We will simply have to make a note of the count that the precinct board took. They will not allow us to verify it. But then I had the opportunity to interview Dean Logan, the Registrar of Voters for Los Angeles County. He had a much different position. If a citizen came to you and said that they wanted to check several precincts where they had believed that there might be some errors in the tabulation of the vote count, and they requested to review the voter rosters to see for themselves if indeed it was accurate, how would you react to a request like that?
Oh, it happens. It happens frequently. I mean, not necessarily because they believe there's a discrepancy, but those are public records, and so we do have people come in after the election and ask to view rosters and to compare those records, and so that's again part of our process. The process belongs to the voters, so our records are available for inspection, and if discrepancies are identified or there are questions left as a result of that, we encourage people to let us know about that, and we would look into that.
Is there any part of the voter roster that is considered confidential, or is it entirely a public document?
The roster itself is a public document. It's if you were to ask to purchase copies of the roster, we would redact certain pieces of information. So, for instance, we would not make copies of voter signatures and provide those to someone else. Now, as far as coming in here and viewing the roster, they could certainly look at it.
Well, very good. We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1, is it possible that the elections codes and the procedures are written in such a vague manner that they can be interpreted differently from one county to the next? Yes or no? Number 2, county registrars are not elected. They're appointed by politicians. Do you think that elected politicians can affect the policies of the voter registrar to the detriment of the voters? Yes or no? Number 3, do you agree with the famous quote from Joseph Stalin? It's not who votes that counts, but who counts the votes. Yes or no? Please be sure to leave your comments below. Thank you. On Tuesday, February 7th, the Los Angeles County Board of Supervisors was reported to having banned beach football and throwing frisbees on the county beaches. Ron Kay is the former editor of the LA Daily News. He's a columnist and a blogger covering California government policies. He thought this policy was completely absurd.
They didn't make any determination of what was broken and how to fix it. The bureaucrats whipped this up and so we'll do it. And they never read it. They just enacted it.
Civic activist John Nahas was incensed at this incredibly ridiculous ordinance and spoke out against it.
So I took off work, I went down, I expressed myself and said, hey, listen, I really think this is a silly code, and basically was ignored. And it was motioned and seconded and so ordered, passed on.
It's a very funny story because imagine what a great headline it is anywhere in the world, is Los Angeles bans frisbees on the beach, when what makes us special is the beaches. That's what makes LA a world famous place, Southern California, is we have these glorious beaches and glorious weather. And then the frisbee playing, ball throwing that goes on all over the world on beaches is banned. And the source of the story is an erroneous news report based on an unintelligible ordinance.
According to Mr. Nahas, this embarrassing situation could have been avoided if the supervisors had merely taken the time to listen to their constituents. He is requesting reconsideration.
We're not feeling that this has been properly vetted in the public, and we want to call for the supervisors to look at this one more time, to allow us the ability to go in and look at these code changes.
Being full disclosure and the news behind the news, we sought to get the story from the county officials who actually wrote the changes in the ordinance. Carol Baker is the Division Chief of the Community and Marketing Services of LA County Department of Beaches and Harbors. She explained the genesis of the whole hullabaloo.
Well, what happened was we were doing a revision to a 40-year-old ordinance, and part of it had to do with this ball and frisbee throwing. There was a report that went out that was inaccurate, that actually said that we were banning frisbees and football, and that the fine would be up to $1,000, which was absolutely incorrect. Unfortunately, the report was on a website, and so it went viral, and it also was part of a very fast-moving news cycle, so it went international very quickly.
As a longtime editor, Ron Kay isn't blaming the media. He suggests that the source is to blame.
They admitted a week after passing it, and actually the supervisors finally reading it and reading what they had approved, discovered that the language about frisbees isn't in there. It's vague about balls and bigger than 10-inch air balls and what you can do in the water with a ball, but it never really says explicitly what it means. And it's easy to read it and misunderstand the fact that for 40 years the county had banned any form of throwing anything on the beach. Now, it was a law that meant nothing because it was never enforced.
Ms. Baker is adamant that the media misinterpreted the ordinance. That's her story, and she's sticking to it.
They certainly didn't double check with us first. I can only speculate that this, with the aggregation of news and the reliance of aggregated news on the internet, the lack of fact checking, the fact that news organizations tend to have fewer reporters and fewer editors than they have in the past, which means that there's less resources to actually roll up their sleeves and do the original reporting. The news cycles are shorter. It could just be a confluence of circumstances that led to the perfect sandstorm here.
This whole idea of how the media blew this out of proportion was not being blown out of proportion. In fact, what the media was reporting was accurate, and that they were trying to continue on the prohibition of football and the use of frisbees and other equipment. And the citizens of LA knew nothing about it.
It would be easy for a reporter reading the ordinance to think that they were banning because it says it's only allowed between Labor Day and Memorial Day. But once the summer's there and the lifeguards are in place, you can't play with these balls. That you have to get a permit from some office somewhere to go to the beach and play. I mean, it's hysterical. And that there's penalties that read to me like it'd be up to $1,000 for being caught throwing a frisbee.
There is a $1,000 fine for misdemeanors in the ordinance. So a misdemeanor that fine would be applicable for would be, for example, discharging a weapon on the beach. That is up to a $1,000 fine. But for an infraction, and most of the ordinances dealing with infractions, the fine is no more than not to exceed $100 for the first violation.
They passed a confusing ordinance that wasn't discussed in any detail in public, that is unusual practice. Everything is hidden. It's very difficult to find stuff on their website.
This should have obviously gone through some kind of public vetting process, which it did not. And then secondly, the fact that we just didn't feel that the supervisors were listening to the public. There's a complete disconnect by what our leaders are doing for what's good for the public.
Ms. Baker thinks the revised ordinance is good for the public.
Now, what this ordinance does is it says during the peak season, we still need to be able to regulate this. So we're going to create opportunities for activities like this to occur during the summer when it can be a little bit crowded.
The problem is much more significant than a silly ban on beach football. This issue underscores the disturbing distance between the people and the government.
My concern in following the supervisors since this incident is that there's a lot of underhanded deals, and we just don't know that these laws are in the best interest of the public, or if they're the interests of private interests, or if it's a revenue generating source for a particular government.
John Nahas doesn't think an ordinance, either the new one or the old one, is necessary.
But we don't think that our open common areas where public come to relax should be those kind of ordeals to where we're now, so concerned about being fined, about, coming down and enjoying our areas and what government's intervention might look like.
The supervisors obviously went ballistic. They were now the laughingstock of the world for doing something that was so believable. And I think that's part of the joke of this thing, is that it was like an April Fool's joke, except it was February 7th.
These video clips are taken from a full-length full disclosure program to be aired on public cable channels and for full disclosure insiders on our website. We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1, did you know that the County Board of Supervisors don't even read ordinances before they approve them? Yes or no? Number 2, do you think that by listening to the public discussion, the supervisors could have avoided this humiliation? Yes or no? And number 3, are you surprised to learn that the county bureaucrats are the ones who draft the new laws? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you. Ron Kay was very critical of the Los Angeles City Council.
The biggest lies that they're telling are all about the money. We gave $300 million to the JW Marriott Hotel at LA Live, and the money wasn't for the deal to make it pencil out to get something valuable. It was because they have to pay the living wage.
Is he saying that the LA City Council is using our tax money to pay the hotel workers? In fact, the answer is yes, as he explained.
The public is paying the wages of the workers, the difference between $8 and $14 or $10 and $14 every day for 20 years.
We're subsidizing the wages?
That's what the living wage is a public subsidy of low-end workers' wages. If you contract with the city, they require you to pay a living wage to all of your workers, at least $10 an hour plus health insurance, or $14 without health insurance.
He explained how the funds are indeed paid to the workers directly from the contractor. But where does the contractor get his funding?
That comes from paying more for the contract. Look, if my business, I can do it for $1 million and you're making me add $100,000 in labor costs, I'm going to submit a bid for $1.1 million. So the public is paying the difference between whatever the salaries were to what they will be under the living wage.
So the unions are deliberately driving up the cost of construction in LA. If you find this obnoxious, just wait until he explains how we're subsidizing the hotels and paying for workers to do nothing during the construction phase.
So they're tearing down the hotel, the Grand Hotel downtown, and Korean Air is putting up a new hotel. They're getting $100 million in half the tax, hotel tax, for 20 years. But they're also, it's going to take a year or two, but they're continuing to employ the workers and continuing to pay. We're paying for that.
Now,
that's our money that's being used to keep these workers from harm.
How does this happen? How can our city fathers, the people we elect as stewards in charge of protecting our public resources, how can they justify squandering our tax money just for the hotel workers? How can the LA City Council violate the concept of equal protection as guaranteed by the 14th Amendment to the U.S. Constitution? They're creating a sweet deal for this particular union and their workers.
It's an ingenious policy from a group that's becoming an offshoot of labor called the LA Alliance for the New Economy. And the new economy is a socialist economy for the few, because we're only talking about a class of people. I mean, if they were honest, they would say everybody in town, the minimum LA wage is $14 an hour. And of course that would drive away all business, wouldn't it? Because we have overwhelmed by poor jobs or the lack of jobs, so that $10 an hour, I mean, hundreds of thousands, vast numbers of people are working for very little.
The main engine that drives this travesty is the insidious circle of money. The taxes we pay go from the contractors to the unions, to the election campaigns for the city council members, and then circles back to the contractors.
Part of that deal is most of the time you have to join the union. Part of the deal is that the company, the hotel company, agrees that the union will represent the workers who will be paid at least the living wage. So you're driving the workers as a condition of employment into the union, for whom they pay dues, which gives the union money to buy the council members. I mean, that's the game, and it's a very sophisticated game today because it's been evolving for 30 years. And it didn't just happen, but it has reached the point where nobody questions the logic of where this money comes from and who's paying the bills and how it comes back to ensure that these things expand and increase.
I've heard the term prevailing wage.
That's obsolete. It's project labor agreements now. A prevailing wage says that if a union carpenter gets $20 an hour on a public works project, you can't pay carpenters less than that, but you can hire anybody you want. Okay, which is the non-union carpenter, which in LA is the largest number of non-union construction workers are Latinos. Okay, it's hard to get into the union. You got to get a union job to get into the union. So you got to know somebody in the union who gets you the job so you can get the union card.
That was the old system. The prevailing wage system has been replaced by the new project labor agreement, as Mr. K explains.
But that's now evolved into project labor agreements, in which the construction company or the employer agrees that as part of the deal of getting city approvals, of getting the city contract, that they will, in essence, only hire union members and union contractors.
Mr. K takes issue with this process because it isn't competitive. It favors the selected class, whoever has the most power.
Again, you are discriminating against whole classes of people and business, both business and labor people, and feeding the money and power of the labor movement to grow its numbers. Nationally, 12% of the American workforce is unionized. More than half of that is in public employees union. It's 16 or 17% now in LA and has been growing.
Why has it been growing? The labor leaders are being fed with piles and piles of money, tax money, our money.
The overwhelming amount of money in city elections comes from labor. So they elect council members who are beholden to them, do what they want, and then carry out laws that, in fact, inflate the numbers and the money, which then circulates back in for more power for the unions. And if you raise these issues, you're anti-union. And I'm not. I believe in unions. Unions are a very important part of a balance of interest. But I also believe in freedom, and I also believe in fairness.
What does this bode for our governments?
Total calamity. It's the only thing that'll shake up the system. There has to be a catastrophic event that probably opens the way to a demagogic ruler or a mass uprising. But the system's frozen. You know, the economic disparities, the disappearance of the middle class.
He is not alone in his pessimistic outlook. Many people are disillusioned by the direction of our current local, state, and federal governments. He recently shared his negative outlook with an associate who agreed.
I met with a writer yesterday, a guy who used to work for me, who's written some books, and we were having lunch. We haven't had any contact in 10 or 12 years. And we were rapping about this stuff, and I said, dummies don't stand a chance in the new economy. He says, that's the book you should write. Dummies don't stand a chance anymore. But it's true, is a person could be pretty stupid, but hardworking and industrious, and have a really good job and a really good income, working in factories, working in a lot of different ways. But those jobs are all gone. They're all overseas. So you need high skills and high training in which case the professional class gets very good wages and has a good life and good benefits. The public sector has very good wages and good benefits, but if you're not in those classes, where's a good living? Where's the opportunity to make $60,000, $70,000?
Working for others is no longer the way to make large sums of money. Only the entrepreneurs with significant new ideas and enough moxie and energy can bring home good salaries. Everyone else is struggling just to make ends meet.
I work at home every day. I get, on average, 2 to 3 calls from guys, voices, 50s. I'm with Joe Stern's construction company, you know, and I mean, I usually just, I'm not interested. But a guy yesterday, I said, I'm really not interested, and I wish I never got these calls, but it's a tough job you got. And he said, buddy, you don't know what it's like. You just don't know what it's like. And I said, no, I don't. And it's really hard out there. I mean, grown men, grown women, the phone solicitation is the last way of making any money, is sitting there with machines and calling people and dying to be friendly. Hey, Ron, this is Marty. Marty? You know, I mean, they all have these pathetic shticks to try to engage you in a conversation. And it's so very, very sad. But it's only the beginning. It only gets worse.
The so-called recovery doesn't seem to have any legs to stand on its own, especially here in California. Drive through any town and look at all the commercial buildings with the signs that say available on them. These buildings are owned by somebody who needs to rent them to make his living, and they are remaining vacant for months, if not years.
We're not societally facing any of it, whether people should only be working. I mean, this guy I was at lunch with yesterday said, you know, you go back in time, in the boom of the 50s, when all the peasants and nobodies of the world became middle class, the belief was that by the year 2000, the average work week would be 20 to 25 hours, that we wouldn't need to work any more than that the machines, and we'd all be rich, relatively speaking, comfortable.
You can't solve a problem unless you identify what it is. Ron Kay is coming up with some ideas on his own.
It's probably true that one of the ways of solving the economic thing is to work less and have less. If you work 30 hours a week in 4 days, you'd have a better life in some ways. And 25% less money, which would also create money and time for other people to have a life. But I mean, we need radical solutions.
This concludes our video blog special. We're interested in what you, the viewers, think. If you would like to answer any of these survey questions posed by these video blogs, or if you'd like to make comments, please call our Full Disclosure Town Hall number at 1-800-867-7777. That's 1-800-867-7777. And if you leave your name and number, we'll get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. I'm Leslie Dutton. Please join us next time for another edition of Full Disclosure. Thank you.
To respond to this question or comment on this program, please call 800-867-7777 or visit fulldisclosure.net. Transcripts or DVD copies of this program are also available on our website. Full Disclosure, the news behind the news. Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're bringing you the news behind the news in this video blog special. Similar to blogs on the internet, Full Disclosure produces short videos of topical issues on our website where we pose questions and invite our web visitors to add their comments to the discussion. We've assembled these controversial programs for you to enjoy here today in this video blog special. Ron Kay was very critical of the Los Angeles City Council.
The biggest lies that they're telling are all about the money. We gave $300 million to the JW Marriott Hotel at LA Live, and the money wasn't for the deal to make it pencil out to get something valuable. It was because they have to pay the living wage.
Is he saying that the LA City Council is using our tax money to pay the hotel workers? In fact, the answer is yes, as he explained.
The public is paying the wages of the workers, the difference between $8 and $14 or $10 and $14 every day for 20 years.
We're subsidizing the wages?
That's what the living wage is a public subsidy of low-end workers' wages. If you contract with the city, they require you to pay a living wage to all of your workers, at least $10 an hour plus health insurance, or $14 without health insurance.
He explained how the funds are indeed paid to the workers directly from the contractor. But where does the contractor get his funding?
That comes from paying more for the contract. Look, if my business, I can do it for $1 million and you're making me add $100,000 in labor costs, I'm going to submit a bid for $1.1 million. So the public is paying the difference between whatever the salaries were to what they will be under the living wage.
So the unions are deliberately driving up the cost of construction in LA. If you find this obnoxious, just wait until he explains how we're subsidizing the hotels and paying for workers to do nothing during the construction phase.
So they're tearing down the hotel, the Grand Hotel downtown, and Korean Air is putting up a new hotel. They're getting $100 million in half the hotel tax for 20 years, but they're also, it's going to take a year or two, but they're continuing to employ the workers and continuing to pay. We're paying for that.
Now,
that's our money that's being used to keep these workers from harm.
how does this happen? How can our city fathers, the people we elect as stewards in charge of protecting our public resources, how can they justify squandering our tax money just for the hotel workers? How can the LA City Council violate the concept of equal protection as guaranteed by the 14th Amendment to the U.S. Constitution? They're creating a sweet deal for this particular union and their workers.
It's an ingenious policy from a group that's becoming an offshoot of labor called the LA Alliance for the New Economy. And the new economy is a socialist economy for the few, because we're only talking about a class of people. I mean, if they were honest, they would say everybody in town, the minimum LA wage is $14 an hour. And of course that would drive away all business, wouldn't it? Because we have overwhelmed by poor jobs or the lack of jobs, so that $10 an hour, I mean, hundreds of thousands and vast numbers of people are working for very little.
The main engine that drives this travesty is the insidious circle of money. The taxes we pay go from the contractors to the unions, to the election campaigns for the city council members, and then circles back to the contractors.
Part of that deal is most of the time you have to join the union. Part of the deal is that the company, the hotel company, agrees that the union will represent the workers who will be paid at least the living wage. So you're driving the workers as a condition of employment into the union, for whom they pay dues, which gives the union money to buy the council members. I mean, that's the game, and it's a very sophisticated game today because it's been evolving for 30 years. And it didn't just happen, but it has reached the point where nobody questions the logic of where this money comes from and who's paying the bills and how it comes back to ensure that these things expand and increase.
I've heard the term prevailing wage.
That's obsolete. It's project labor agreements now. A prevailing wage says that if a union carpenter gets $20 an hour on a public works project, you can't pay carpenters less than that, but you can hire anybody you want. Okay, which is the non-union carpenter, which in LA is the largest number of non-union construction workers are Latinos. Okay, it's hard to get into the union. You got to get a union job to get into the union. So you got to know somebody in the union who gets you the job so you can get the union card.
That was the old system. The prevailing wage system has been replaced by the new project labor agreement, as Mr. K explains.
But that's now evolved into project labor agreements, in which the construction company or the employer agrees that as part of the deal of getting city approvals, of getting the city contract, that they will, in essence, only hire union members and union contractors.
Mr. K takes issue with this process because it isn't competitive. It favors the selected class, whoever has the most power.
Again, you are discriminating against whole classes of people and business, both business and labor people, and feeding the money and power of the labor movement to grow its numbers. Nationally, 12% of the American workforce is unionized. More than half of that is in public employees union. It's 16 or 17% now in LA and has been growing.
Why has it been growing? The labor leaders are being fed with piles and piles of money, tax money, our money.
The overwhelming amount of money in city elections comes from labor. So they elect council members who are beholden to them, do what they want, and then carry out laws that, in fact, inflate the numbers and the money, which then circulates back in for more power for the unions.
We'll be right back.
In the government, there's a phrase used to restrict access to information. That phrase, need to know. At fulldisclosure.net, We want you to have all the information you need to be an informed citizen, unlimited access to all the information we've gathered on our TV show. And if you can't watch us on your local cable station, streaming video of complete shows when you want them. FullDisclosure.net, when you need to know the news behind the news.
Things don't last forever. We need to recognize that things can change. And if we take it for granted, like we don't need to be involved, we will lose many of the things that we grew up with, that we loved about being Americans or Californians or Los Angeles residents, because it'll change. Every time you click on Full Disclosure or see a Full Disclosure program, it's shocking the important news which is being neglected by the major media outlets.
Welcome back to Full Disclosure and our interview with longtime journalist Ron Kay. Mr. Kay explains how once beneficial unions mutated into these resource-gobbling monsters that destroy free enterprise.
The labor movement didn't just get to 12%. When I was a boy, it was 40%. They stopped organizing, they stopped fighting, and became protective of what they had, particularly in the crafts, particularly in construction trades, in auto workers, and steel workers, and the highly paid jobs. They didn't want more workers, and they didn't want to fund a labor movement that organized other workers around other industries. So they don't represent working people, they represent themselves. And if they were honest about that, it would be healthier. But to accept that they represent working people is just fallacious. They represent the union members.
This circle of money seems to be firmly entrenched with the no apparent way to stop the cycle of corruption. We ask him, what will it take to change the current status quo? He was not optimistic. What does this bode for our governments?
Total calamity. It's the only thing that'll shake up the system. There has to be a catastrophic event that probably opens the way to a demagogic ruler or a mass uprising. But the system's frozen. You know, the economic disparities, the disappearance of the middle class.
He is not alone in his pessimistic outlook. Many people are disillusioned by the direction of our current local, state, and federal governments. He recently shared his negative outlook with an associate who agreed.
I met with a writer yesterday, a guy who used to work for me, who's written some books, and we were having lunch. We haven't had any contact in 10 or 12 years. And we were rapping about this stuff, and I said, dummies don't stand a chance in the new economy. He says, that's the book you should write. Dummies don't stand a chance anymore. But it's true, is a person could be pretty stupid, but hardworking and industrious, and have a really good job and a really good income, working in factories, working in a lot of different ways. But those jobs are all gone. They're all overseas. So you need high skills and high training in which case the professional class gets very good wages and has a good life and good benefits. The public sector has very good wages and good benefits, but if you're not in those classes, where's a good living? Where's the opportunity to make $60,000, $70,000?
Working for others is no longer the way to make large sums of money. Only the entrepreneurs with significant new ideas and enough moxie and energy can bring home good salaries. Everyone else is struggling just to make ends meet.
I work at home every day. I get, on average, 2 to 3 calls from guys, voices, 50s. I'm with Joe Stern's construction company, you know, and I mean, I usually I'm not interested. But a guy yesterday I said, I'm really not interested, and I wish I never got these calls, but it's a tough job you got. And he said, buddy, you don't know what it's like. You just don't know what it's like. And I said, no, I don't. And it's really hard out there. I mean, grown men, grown women, the phone solicitation is the last way of making any money. Is sitting there with machines and calling people and dying to be friendly. Hey, Ron, this is Marty. Marty? You know, I mean, they all have these pathetic shticks to try to engage you in a conversation. And it's so very, very sad. But it's only the beginning. It only gets worse.
The so-called recovery doesn't seem to have any legs to stand on its own, especially here in California. Drive through any town and look at all the commercial buildings with the signs that say available on them. These buildings are owned by somebody who needs to rent them to make his living, and they are remaining vacant for months, if not years.
We're not societally facing any of it, whether people should only be working. I mean, this guy I was at lunch with yesterday said, you know, you go back in time, in the boom of the 50s, when all the peasants and nobodies of the world became middle class, the belief was that by the year 2000, the average work week would be 20 to 25 hours, that we wouldn't need to work any more than that the machines, and we'd all be rich, relatively speaking, comfortable.
You can't solve a problem unless you identify what it is. Ron Kay is coming up with some ideas on his own.
It's probably true that one of the ways of solving the economic thing is to work less and have less. If you work 30 hours a week in 4 days, you'd have a better life in some ways, and 25% less money, which would also create money and time for other people to have a life. But I mean, we need radical solutions.
It is very important that everyone pay attention to what's going on and then join the cause. Always appreciated the diligent pursuit of truth that Full Disclosure has provided. Full Disclosure does a wonderful job of presenting the rest of the story.
Full Disclosure is producing a movie entitled The Cost of Courage. It's a documentary that chronicles the frightening story of Dr. Richard I. Fine, who took on the judges of the Los Angeles Superior Court. We were there in the courtroom at that historic moment when Richard Fine was arrested to begin his unwarranted 18 months of solitary coercive confinement. But even though we had petitioned the court, we weren't allowed to record the event on our cameras. We finally got a copy of the video footage of his arrest. We wanted to go back to that courtroom to record the moving speech that Dr. Fine gave moments before his arrest. It is essential to our movie because Dr. Fine meticulously identified how the Judge David Yaffe, was violating the law by sitting on the case. This sequence provides the explanation why Dr. Fine spent 18 months in jail. We petitioned the court to get access to an empty courtroom and got the bureaucratic runaround. For us, this became a First Amendment issue. As the media, we have a right to use public facilities to discuss public issues. While fighting the resistance of the court, we noted that CNN was given full access to the same courtroom when they did a short segment on Dr. Richard Fine. Why shouldn't Full Disclosure have the same access? In an apparent attempt to exhaust us, we were shuttled from one court official to another. We were told to contact the facilities manager, and then the presiding judge, and then the court counsel, and then back to the facilities manager. We filled out form after form and submitted our proof of insurance and jumped through every hoop the court threw in front of us. After we had complied with every requirement, the only response we got was silence. So we decided to force their hand. We contacted our friends at Judicial Watch. Their first approach was very measured and not confrontational at all. Paul Orphanides, their director of litigation, got a more definitive response.
And then we wrote a letter. And then when we wrote a letter, they wrote us back saying, no, you wouldn't be allowed this access. So we filed a lawsuit on your behalf.
He described the thinking behind the lawsuit.
Federal property that the government, federal or state or county, whatever sort of government property that is made available for public use, the government can't deny you access to that unreasonably. It can't act arbitrarily or capriciously, and it can't discriminate against you on the basis of your viewpoint.
These are solid, reasonable arguments that should easily stand up in court, and that's who we sued.
So we filed this lawsuit against the Chief Judge of the LA County Superior Court, against the judge who presides over Department 86, and against the General Counsel to the LA County Superior Court, who authored some of these letters saying no, for violation of your First Amendment rights.
And he described the result of this solid, reasonable lawsuit, which the court dismissed with prejudice.
We had a hearing yesterday in front of Judge Manny Real. Well, it wasn't much of a hearing, it was more of a reading of a decision, I should say. That apparently is what the court's process is. The court granted the motion to dismiss. It said that these facts that we had pled in our complaint, they don't add up to a claim for a violation of your rights.
What? The facts don't add up to a claim for violation of our rights? Mr. Orphanides had difficulty understanding their reason for dismissing our suit.
The fact that you fulfilled all the criteria for being allowed this access, and that they couldn't even give you a reason for why you were being denied access, that to us shows just the arbitrary and capricious nature of it, the fact that they didn't have a good reason to deny you access.
Interestingly, the court hired the world's largest, most powerful law firm to represent them, Jones Day. Who paid for this high-powered team of lawyers to stop our little video recording session?
We don't know how it was that Jones Day was hired to represent the court. It just happened to be one of the same attorneys that represented the court in the judicial benefits case. And there's no opportunity for us to find out. There's no transparency, there's no accountability in any of this sort of court administrative process.
Just released a few weeks ago was this massive report on the Administrative Office of the Court by the court-appointed Strategic Evaluation Committee. This report took issue with some of the top-down edicts by which the court operates. We asked Mr. Orphanides if the decision to dismiss our suit came from way up the food chain. But according to this, it would appear that the decisions are being made at a higher up level.
It could be. It could be. I still think, well, we don't know. I mean, we don't know who was making the actual decisions. We believe in your case that it was the chief judge, that it was the general counsel, and then it was the judge in Department 86. We don't know what role the administrative office might have played. But this report does highlight the sort of a lack of transparency in anything involving sort of the administrative process and operation of the courts. And this report, it's pretty horrible in terms of there being a lack of transparency and a lack of oversight.
The dismissal of our lawsuit never addressed the issues that Judicial Watch brought forward in the suit.
There certainly is no reasonable or rational explanation. I mean, you asked for approximately a half hour's worth of time. Any time the court was available, any time the courtroom was available. There's no. You satisfied all the conditions and requirements and all the licensing application process. There's really no reasonable reason for them to have denied you access.
But they did. The court is supposed to dispense justice according to the rule of law. Somehow, that doesn't seem to work out like that.
The California court system is an enormous court system, and you end up with bureaucracies and entrenched interests and egos and personalities and ambition and all that. And sometimes justice is maybe what the purpose of that is supposed to all be about, but it gets somehow lost in the shuffle behind all the the bureaucracy.
We asked him if he thought this was an issue worth pursuing on appeal.
Absolutely. I mean, I think one of the things that this lawsuit, well, one of the things that it has the potential to do is to force the court to develop some sort of regular process and procedures for considering these types of requests. I mean, we know that they allow the public to make use of their court facilities after hours. There's a form, but yet there really aren't any rules or regulations or guidelines. There's no set process or procedures. I mean, you basically got a runaround in terms of you made multiple requests to multiple entities. Finally, you were told to file this commercial application with the court facilities office. And, you went to great lengths, did everything they told you to do, and, ultimately the answer was no, no, no. But hopefully one of the things this lawsuit can do is to spur the court to come up with some sort of regularized process for making these sorts of, for considering and responding to these kinds of requests.
He's enthusiastic about seeing this case to its end. In light of the fact that the budget crisis is causing the bureaucracy to abandon 52 courtrooms, they should be able to find some way to squeeze in full disclosure so we can complete our documentary.
If we go to the appellate court and the appellate court reverses, we'll get the case back, and then we'll get some discovery. We'll be able to ask some questions to the court about its processes and its thinking behind not just what happened here, but how this process is supposed to work, that they've got 52 courtrooms that they're not going to use anymore, and they're not going to let the public use them either. It just doesn't make any sense.
We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1, do you think the court's arbitrary decision to ban Full Disclosure Network's First Amendment right to use an empty courtroom should be appealed? Yes or no? Number 2, do you think that the mainstream media outlets will support full disclosure to challenge the court's arbitrary ban of the Full Disclosure Network? Yes or no? Number 3, why was CNN allowed to use the courtroom and not Full Disclosure? Do you think the court is showing favoritism to the mainstream media? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you.